Hello, I'm Baijal. I lead the Insolvency team here at BBM. In this short video, I want to speak to directors of companies who find themselves in financial distress. For example, creditors putting on pressure, or for example, the company not being able to pay its invoices timeously. We frequently have directors of companies come to us directly or referred by their accountants looking for advice about what duties they owe in law in this type of scenario. I suppose the best advice I could give you is that if you're a director that finds yourself in this type of circumstance, it is incredibly important, in fact it's vital, that you take independent expert insolvency advice. This is one of these areas where it's not lawyers being dramatic. If you do not take the appropriate advice and you do not follow what your legal obligations are, then you could find yourself in a worst case, even though you're director of a limited liability company, find yourself personally liable for some of the debts of the company. You could also find yourself subject to disqualification proceedings by the Secretary of State for Business if your conduct falls below what is expected of a director. In a worst case, particularly where there's dishonesty involved, you could even face potential criminal prosecution. When directors come in to see us, the first question we generally have to address is this: is the company insolvent or not? That's not always quite as easy as you might think to be able to make a decision about. It's not as simple as simply looking at the balance sheet. Obviously, if a company is balance sheet insolvent, that is, its liabilities outweigh its assets, then directors would need to be very cautious about carrying on. In fact, unless they have something legally binding in the form of guarantees or support from a director or from a parent company, in most cases it will be very dangerous for them to carry on trading. However, even if a company is a balance sheet solvent, it may be cash flow insolvent. That is, although its assets outweigh its liabilities, is unable to pay its debts as they fall due. If, in fact, the directors conclude with the help of expert advice that they cannot reasonably expect things are going to get any better, and in fact, in some cases, things might get worse, sometimes the only reasonable decision to take at that stage is to stop trading. If the advice is that for some reason it's felt that perhaps because of a contract to come or for some other reason it is reasonable to continue trading, it's very important that directors document in the form of board minutes and professional advice why it is okay to continue trading. That may provide some protection if matters are looked at after the event, for example by a liquidator or an administrator. If the advice is that the company is insolvent or is verging on insolvency, directors need to understand that there are a whole suite of legal duties that then fall upon them, as well as all the normal directors' duties such as to act in the best interests of the company. Directors at the point of insolvency or at the point the company is verging on insolvency start to owe duties in a particular way to the creditors of the company too. I've mentioned already the fact they can't continue to trade when things are not going to get any better. If they do continue to trade when they ought not to, that is known as wrongful trading, or in a worst case, fraudulent trading. In either of these cases, the director can be made personally liable by the court for the difference in the losses, in the shortfall that the companies suffer and therefore the creditors suffer. In addition, at this point, directors need to be very careful to treat all creditors equally. The law stops directors from unfairly preferring one creditor to another. So, for example, it's not acceptable in law to pay off the local creditors or perhaps pay down the bank to whom you owe a personal guarantee and leave Her Majesty's Revenue and Customs without being paid. In fact, that's the kind of conduct that may give rise to disqualification proceedings in any insolvency that then follows. It's also very important to understand that a company should not be making any gratuitous alienations. What that means practically is directors need to ensure that assets of the company are not sold at undervalue. So if in the lead up to an insolvency, assets of the company are being sold, it's very important that there's vouching and documentation in terms of the value of the asset and what was actually paid for them, so that it can be shown that there was adequate consideration, which is the legal term for the payment received, actually coming in. There's some of the issues that face directors. There are many other things directors need to have advice about, not only, for example, the choice of what restructuring method is the appropriate one for their company, but also the personal effect of insolvency on them. Are there any personal guarantees that they've given that need to be thought about? How are they going to recover financially from the insolvency of the company? In any and all of these areas, we try to provide helpful and practical advice. However, whoever you receive advice from, the important thing is that if you are a director of a company that is in financial distress, that you take independent, expert legal advice in this area as soon as possible.